Hi all, it's Tom Crawford here and Guy Taylor, and we're addressing the judgment that was passed down on the 14th of May. Now there's a lot of confusion with the judgment, and we hope to explain the ins and outs. This is part one of a two-part series, but I'll address one first thing that's been put out about two questions. The very first one was there was a possession order in 2006 that came about, which I explained in one of my videos or in a talk I did, that we wanted them to change the mortgage from the part and part back to the endowment, and the only way we could do it back then, because we didn't know the law, we simply refused to pay them any more money. Then they instigated possession proceedings. At that point we paid up. We got scared because they might take our home, and I think we were right, because they came afterwards and did exactly the same thing when I was ill and couldn't pay it. So that is the reason why that original possession order, we instigated that, but it didn't work. The second one was the £173 that they keep on going on about, that was paid into Sue's account, allegedly. Now, you haven't seen the documentation. I've already put it up on the internet, but they refer to a totally different account number. It hasn't been agreed in the court. The judge knows there's differences, and he remarked on it. So that's another load of nonsense. And for this here, because we both now agree that there was an endowment, they've backtracked. I've held to that all these years. And this document here, from the second paragraph there, quite clearly states that it has been changed. It's been changed to a part and part, and it is no longer endowment. So they lied in court. And as I said before, this part here, the last one, where they sent us a gift saying, terribly sorry, we're not really criminals, we'll just send you some flowers, and that. I hope that's addressed that confusion. Now on to the judgment. And the judgment is the confusing part for people, because people are just reading the letters and the words on there as in English, but it's there to confuse you and us, and will also refer to the actual judgment of order, which was passed down after that. So I'll pass you over to Guy, and Guy will be more precise in the interpretation of a lot of this judgment, and then part two will be the judgment deciphered in each section. So
we'll firstly go into the skeleton argument for the appellant, and you can see that section 45 of the skeleton argument states this: A is therefore seeking an order setting aside the judgment and all the orders which arose out of it on the ground stated herein, relying upon in R.E. Barrel Enterprises 1973, Flower v. Lloyd 6 CHD 297, and pursuant to the Supreme Court Practice 1970, page 327, which states that if a judgment or an order has been obtained by fraud, or where evidence which could not possibly have been adduced at the original hearing is forthcoming, a fresh action will lie to impeach the original judgment. So that's on there. Now, in Tom's case, right, in the skeleton argument, there is also, in the county court judgment, there is also recognition of fraud, as mentioned before the start of section 75.
that's hardly unusual.
Hardly unusual. And here we go on to the arrears quantification in the judgment, where the judge clearly says, section 90, Mr. Crawford does not admit that the figure alleged to be outstanding on the total mortgage debt is correct, nor, I think, does he agree with the total arrears figure. Here, Mr. Crawford has a point. I can find nothing on the statement of account which show when capitalizations have occurred, although the total mortgage debt figures are more readily understandable. From January 2010, the format of statements of account changed, but it is not easy to see at any given time what the live account arrears are. At the time of commencement of the possession proceedings, arrears were said to total £1,802.90. That is not a figure which I could identify from the statement of account. When asked where it had come from, Miss Sandals for Bradford and Bingley told me that it came from the computer. As computers should be our slaves and not our masters, such a response is not satisfactory. I can't be plainer explaining what that's about, and we've said it many times because it's a key point of the entire judgment. If we go on to the judgment or order,
that's basically telling the barrister she lied.
Yes. And if we go on to the original judgment order and we look, we see that it's a general form. We see that it's not a seal, that's a stamp. And I'll go on later to explain, or I'll show now, that is a seal. And this is where the court documents start getting very shaky. Because if you give me, this is in another case, but they're both claims for possession of property. That's a claim for possession of property, and that's a claim form. You'll see that that one hasn't even got a seal on it, nothing at all. This one has a seal. Now when we turn over the page there, on this one, again this is another fraudulent instrument, you'll see where it's signed. You'll see the name Adam Penman. When you turn over on this one, which is a real one, you'll clearly see that where it's signed, it's been signed, not printed. Whereas on that one, they're both printed. So again, that's just showing you the level of what's going on inside these courts and how to recognise when they're a real document or when they're fraudulent. But going back to Tom's, so we've got over the issue of the seal. On 2 it says, permission to appeal is refused. Well, permission to appeal is refused. And we go to section 45 of the skeleton argument, which is the Flowers v. Lloyd case. And it states that if a judgment or order has been obtained by fraud, or evidence which could not possibly have been adduced at the original hearing is forthcoming, a fresh action will lie to impeach the original judgment. So that is clearly what has gone on in this case. So he couldn't make a stay on the warrant for possession, as there never was one presented in evidence. There was never a warrant in Tom's case presented as evidence. We've been asking for the warrant since day one. There's a notice of eviction, which is what he's basing it on, but not the warrant.
That's what he's executing.
That's exactly right, yeah. That's what it is. There is no warrant in this matter. If there is a warrant, show us it. That's what we've been asking. And but we know that there isn't, and we know that there's never even been a case through the courts themselves. I know that's not complicated, but it's an area I can break into once we've finished where we are on this. Yeah.
Okay, so that's the information that Guy has just put to you. Now I'll just do a bit more clarification on the actual order. Now the order is a follow-up of the judgment. The judgment is pronounced in court in front of witnesses. Sometimes not, but generally in front of witnesses. Then he passes down the order, which is the official sealing of the document, so then it becomes an actual proper court document. This is it here. Okay. Now I think maybe that'll be held for you so you can see. So going to the seal, when you compare it to the one that Guy just held up, that particular one, you can see the seal on this judgment isn't a seal, it just says County Court. And this one, it is a proper seal. Now the difference being is a seal is to state when the document was sealed and where. It should have had, as that one did, the date on the day that the judge pronounced judgment and where he pronounced judgment, and that has to be on the seal to make it an official document. So this isn't a court document, this is a forgery. Second is, when we talked about where it was sealed, well, he's got the county court at Nottingham. Everybody knows throughout this country that it was in the children's court, the family and children's court, and it was, he says it's a justice centre. So that's two right away. Sue and myself put in a claim to have the judgment set aside. Now the reason that I become a claimant is because I paid the money and put it into court, but God's Mark, in his wisdom, he's decided to reverse the roles. So in this, Bradford and Bingley become the claimants and we become the defendants.
Hopefully you're going to get your court fees back then.
Apparently he can change these things. Now if we go to the actual his judgment, where he says, upon hearing Mr. Crawford in person, and in brackets, assisted by his Mackenzie friend, Mr. Benicia. So, he's only listening to me now. He didn't listen before, because I'm telling him now the sky is tartan, because he can put it into an order. He should have said, upon hearing the evidence.
Upon reading.